I don't believe the change of ownership was a secret, but the terms of it are not disclosed publicly, just like every other private business transaction.
So the contract for the sale of 7800 East Harry is a secret and is protected.
Right from the start, this Kansas courtroom introduces a serious Level 5 meth possession charge, with the defendant pleading not guilty and pushing towards trial. But beneath the calm exchange, scheduling tensions are already building. Dates could decide everything here. Subscribe now for more intense courtroom drama and expert breakdowns.
Good afternoon.
Afternoon, Your Honor.
Hello. Are we expecting anybody else today?
Not to my knowledge.
No, Your Honor.
All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled CMK Enterprises Incorporated versus Jennifer Ferguson and Papa John's, case number 24 LM 1364. Would counsel announce appearances, please?
Please, the court. I'm Scott Hess on behalf of CMK Enterprises, the plaintiff judgment creditor in this case.
Good afternoon, Your Honor. Papa Texas LLC appears through counsel Ed Robinson. Also present is a representative of Papa Texas, Chad Taylor.
All right, thank you, counsel. We're set today for hearing on motion for relief from judgment filed on behalf of Papa Texas. Mr. Robinson, are you ready to proceed on your motion?
I am.
All right, I did receive also an opposition to motion for relief from judgment, a reply in support of that, and then a supplemental motion filed by Mr. Hess. Are there any other filings in regard to the motion other than those?
There are no filings, Your Honor.
Okay. All right, Mr. Robinson, I'll allow you to argue your motion at this time.
Okay. Your Honor, just a couple of brief remarks. We're here on a motion for relief from judgment. It arises under KSA 60, 260B4 and 6. In the present motion, Papa Texas requests relief from a garnishee judgment that was entered with respect to a Papa John's location owned at that time by another company referred to as or known as PJ Ops Kansas LLC. The location of that Papa John's restaurant is 7800 East Harry in Wichita, Kansas. PJ Ops's garnishee judgment was entered in 2018. Papa Texas purchased the assets of that particular location from PJ Ops in 2022. As noted in the briefing, the general rule is that Papa Texas should not be liable for the judgment that was entered against PJ Ops. That rule was recently stated in Wells Fargo Vendor Financial Services LLC versus Nationwide Learning, and that's quoted in the opening brief. In that case, the court held that when one corporation sells or transfers all of its assets to another corporation, the purchasing corporation is not liable for the debts of the selling corporation. There are 4 recognized exceptions to the rule. The first is if a purchaser expressly or impliedly agrees to assume the debt. The second is that is when the transaction amounts to a consolidation or merger of the corporations. The third is if the purchasing corporation is merely a continuation of the selling corporation. And the fourth is if the transaction is entered into fraudulently to escape liability for the seller's debts. The burden of proving those exceptions rests with the judgment creditor, CME Enterprises. The Kansas Supreme Court has held that, quote, as a general rule, the burden of proof lies with the moving party or the party asserting the affirmative of an issue. That was recently stated in NRA KE 294 Kansas 17 syllabus paragraph 3 in 2012. In its briefing, CME did not meet that burden of proof of showing that any of those exceptions should apply. The bulk of its position rests on the fact that CME Enterprises conducted a till tap of a Papa John's location in 2022. And I would note, Your Honor, there has been a recent development or discovery that will show up in the evidence. And I had recently sent an exhibit to the court's assistant and also to Mr. Hess. The asset purchase agreement anticipated that the transaction between PJ Ops Kansas LLC and Papa Texas LLC would close on May 15th, 2022. In fact, we located the settlement statement for that transaction, and it is an Exhibit 10 that I've sent to Mr. Hess, and I emailed to the court's assistant. That transaction actually didn't close until June 16th of 2022, and those two dates are going to be important. The bottom line is that till tap occurred before Papa Texas closed on this transaction and took over the Papa John's location at 7800 East Harry. The remainder of CME's position rests on the argument that Papa Texas did not make any distinctive changes to the location after it took over from PJ Ops. But the evidence will show that franchise locations such as Papa John's are designed for customers to recognize the brand, not the underlying location of that brand, or not the underlying owner of that location. And the bottom line is that if CME Enterprises' argument was the rule, there could never be an asset purchase of any franchise location in Kansas, regardless of what the seller or buyer might intend. As a result of this, Papa Texas asks this court to rule that CME's garnishee judgment against PJ Ops is not enforceable as to Papa Texas. It does not ask for any ruling on the enforceability of the garnishee judgment as to PJ Ops. Your Honor, I'm going to call Mr. Taylor to testify and ask him some questions. Before I do so, I would move to admit Exhibits 1 through 8 that have already been provided to CME Enterprises and to the court. Those are previous filings in the action, and I believe the court can take judicial notice of those filings.
I have no objection, Your Honor.
I'm sorry, Mr. Hess?
I have no objection.
Okay. And Mr. Hess, I don't know, your audio comes through a little bit muffled on my computer here. I don't know. I think it was better the closer you were.
Does that help any?
All right. All right. So 1 through, which numbers were you seeking to admit, Mr. Robinson?
1 through 8.
1 through 8. So those are admitted at this time. Mr. Hess, I'll give you an opportunity to make an opening remark if you'd like before Mr. Robinson takes testimony from Mr. Taylor.
Your Honor, as you can see from all the documentation that has been filed in this particular case, I don't think Papa John's or anybody knows who owns what or knew who owned what at all during this matter. We got a judgment against Papa John's at 7800 East Harry in 2018. We executed against that. We did a till tap. We did a till tap too in May 15th of 2022, which, according to all the documentations that I've seen up until today, was purchased by Papa John's of Texas, whomever. Now, I got a phone call from Mr. Taylor after we till tapped this thing in 2025. Returned my phone. I wasn't here. Returned the phone call to him. I have had contact with previous attorney, Ms. Laura Smith. We have attempted to get this thing taken care of. Never have found out who owns this particular restaurant until after this, the sales agreement was provided about 2 weeks ago. It's our belief that we tapped the same restaurant that we had previously got a judgment against and till tapped before, and we believe that we tapped the right place, and we have all the reasons that were set forth in my brief. I would also like to note that 3 times I have offered on behalf of my client to pay the $555 back or $550 back, and they've refused 3 times. I don't know why we're here right now. We've offered to give them, and only based upon the representation that Ms. Smith made, that maybe that the property had sold. As a matter of good business, we decided just to offer the money back, and they've refused to take it. Why we're here, I don't know.
Mr. Robinson, do you know anything about this offer to return the money?
Now things get interesting. Jury trial scheduling hits a wall. Limited court availability, overlapping cases, and even personal commitments are shaping this timeline. The defense seems flexible, but delays can cut both ways. Is this strategy or necessity? And in your opinion, who benefits more from pushing this case further out?
So, Your Honor, and Mr. Taylor can testify to this if needed. What had happened was, as I understand it, after this till tap had happened, Mr. Taylor contacted Mr. Hess and asked for the funds to be returned. That was back in, I believe, August. It was the same day. It was August 19th. It was the same day the till tap occurred.
And with response to that, Your Honor, Mr. Taylor called and left a message. I called him back. He did not return my call. I've got it on recording, and I can provide that's the court needs be. Mr. Taylor didn't return my call. And the next contact I had was with Miss Maura Smith with Martin Pringle, I think. That's who it was.
All right, Mr. Hess, I don't know. I'm having a very hard time hearing you. But is anybody else having an issue hearing Mr. Hess?
I am, yes.
I'll turn it up some. How's that?
Well, I don't know what to tell you. All I know is it's kind of faint coming through my speakers. But I can make out most of it, Mr. Hess.
Yeah, and in addition to talking to Miss Smith, I talked to Mr. Robinson on the phone, told him my client would give the money back. Got a rejection on that. I even sent a letter on, what day was that? January 20th, 2026, and we'd give the money back. There's no issue. While we believe we have justification to keep the money, based upon the representations of Ms. Smith that there was a sale and we have not seen the documents until 2 weeks ago, we offered to give the money back.
Is that still your position?
Sure. We'll give them $550 back. That's our position.
All right. If that's the case, Mr. Robinson, what are we doing here?
Well, what we're doing is we're asking for this judgment to be set aside with respect to Papa Texas LLC. What I understand Mr. Hess to be saying is that he's willing to return the funds, but he's not willing to agree that the judgment is unenforceable as to Papa Texas LLC.
I said that I would not attempt to Ms. Smith told him I wouldn't attempt to collect against Papa Texas or Sun Holdings or whoever this group is, but it asked them to give us addresses of Papa Texas so that we wouldn't do it. And they didn't give us those either.
So-
If
Go ahead, Mr. Robinson.
if Mr. Well, if Mr. Hess and his client agreed that this judgment was unenforceable as to Papa Texas LLC, they could have agreed to that after we filed our motion. But what let me finish, please. The position that they've taken is in the briefing is that this judgment is enforceable against Papa Texas LLC. And what we're asking the court to do is issue a ruling saying that this judgment is not enforceable against Papa Texas LLC.
Only after they rejected us, giving them the money back, did we file the legal position that we believe is valid, that we are entitled to the money. Now, these folks, I never mind. We have offered to give the money back. We also asked for a list of Papa Texas's restaurants that we wouldn't tap, we wouldn't try to get a hold of, and they haven't given it to us.
All right, so Mr. Robinson, you're not satisfied with what's been proposed here. Is that accurate?
Right. So, Your Honor, so the bottom line of this, and again, Mr. Taylor can testify to this as needed, and because I was not the original attorney on this when it arose, is Mr. Taylor contacted Mr. Hess, asked for the money to be returned. After approximately a month, the money had not been returned. So Mr. Taylor, well, Papa Texas LLC retained counsel in Wichita, and they sent a demand letter to CME Enterprises and Mr. Hess explaining the nature of this transaction, and that they demanded the return of the money, and they demanded the attorney fees that were incurred in presenting that position. And it's been the position, as I understand it, of Mr. Hess and CME Enterprises, is that they will not reimburse Papa Texas for any attorney fees that have been incurred in dealing with this matter. And they've also never been willing to state on the record that this judgment is not enforceable against Papa Texas LLC. So what we're really dealing with at the end of this day is a wrongful execution. This was a wrongful execution that was done by CME Enterprises against Papa Texas LLC. And in order to perfect a cause of action for wrongful execution, Papa Texas is required to establish that the judgment is void or unenforceable as to it. So this is really a step one where we anticipate a step two, a cause of action for wrongful execution of a judgment. So that's really kind of the background of it, is we need this ruling to establish this cause of action. And that's a big part of why we're here today. If CME Enterprises was willing to agree that this judgment was unenforceable as to Papa Texas, we wouldn't be here. We wouldn't be having this hearing. But CME Enterprises is taking the position that that this judgment is enforceable as to Papa Texas LLC, and so that's why we're asking for a court ruling.
We have offered to give them the money back. We also said that we wouldn't collect against Papa Texas. We didn't get to see the contract until 2 weeks ago. We ran up against a brick wall the whole time. And I'd also like to add that after I talked to Mr. Taylor in August, I went through 2 kidney stone surgeries and was not available, pretty much out of pocket, for a month. Now, I did call Mr. Taylor back the very day that he called me, and he did not return my call. I immediately got a hold of the folks Ms. Smith as soon as I could get back. We tried to get this thing resolved, and they've just been obstinate about it. I don't see any reason why they should get attorney's fees in this matter. There's no statutory authority for it. I've asked them for statutory authority for it, and they haven't given me any. And there's no reason for us even to be here, Your Honor.
All right. Well, here, the way I'm understanding the current posture of the case is absent a agreement from CMK Enterprises that the judgment is void as to Papa Texas, then we're proceeding to a hearing. If that's the situation we're in, then I'd just like to get started.
The facts are all there, Your Honor. We believe that we had a reasonable belief to bring a till tap against these folks. They owned the property at the time, and they agreed, and they paid it off. I mean, I'm at an impasse here. I don't understand what's going on.
All right, I understand your position, Mr. Hess, is you feel that you guys or CMK did a reasonable execution of the till tap. Papa Texas' position is that it wasn't. If we need to take evidence or y'all want to put on more, we can do that, and I can make a ruling, or I can make a ruling based on my review of the briefing.
By the end, the judge locks in multiple dates, balancing uncertainty with structure. This isn't just scheduling, it's positioning for trial under tight constraints. Every delay could shift leverage. The case is set, but far from decided. Like, comment, and subscribe for more gripping courtroom breakdowns and real legal drama.
Your Honor, I would request as part of the record that we take Mr. Taylor's testimony. And really the question today for the court is not, was CME Enterprises actions reasonable on August 19th, 2025? Really the only question, the single question for the court today is this garnishee judgment against PJ Ops Kansas LLC enforceable against Papa Texas LLC? That is the one and only question that we are asking this court to decide today.
All right.
If they have going to put on evidence, I've got recordings of telephone calls where I've tried to deal with these folks before, and I'd like to present that as evidence too. But I've got it on a flash drive, and I need to send it down to the court for your review.
All right. What's on the telephone calls between who?
It'd be phone calls between myself, not between me, it'd be between Mr. Taylor and my staff. I was out of the office at the time, and phone call from me to his office trying to establish contact with him. I also have the recording of the phone call with Laura Smith, and I also have a recording of a phone call with Mr. Robinson where I talked to him about this and basically said, we're going to give you the money back if you want it, and they wouldn't take it.
Your Honor, I understood the deadline for submitting any exhibits was Monday of this week. I haven't received any exhibits from Mr. Hess. Sounds like Mr. Hess hasn't produced any exhibits for the court.
Well, then the number 10 today was late too. I'm playing with a moving target here, Your Honor, and I would like to present that I had no understanding of what these people wanted, and I would sure like to get these other facts in front of the court if it's taken facts.
Well, I'm trying to think how relevant that these phone calls are to the ultimate determination here. I mean, I understand that you offered to return the money.
I also asked for a contract or something that would prove to me that these guys owned the property. I didn't get it until just recently. That may have changed my position. Well, I offered to anyway, just based upon their representations to me that they owned the property. We had no idea that they owned this restaurant until the message that Mr. Taylor left gave us a kind of a general idea. I didn't know about who owned the property until the contract was produced earlier this week.
Was that through the protective order?
Yes, it was.
Well, I guess I'm still not sure what the recording of the phone calls is going to.
Showed that I asked them for information about the sale of the property. We had no idea of knowing that this restaurant was owned by anybody besides who owned it when we got the judgment against it.
Well, two things there, Your Honor. Mr. Hess's position is it doesn't matter who owns it because they can tilt-tap the location. And as long as they're tilt-tapping the location, the action is valid and enforceable. And we simply disagree with that notion. The second point is it doesn't, regardless of what was discussed, apparently recorded, I guess Mr. Hess recorded his phone call with me after August 19th, 2025, does not change whether this judgment is enforceable against Papa Texas LLC.
If they bought the restaurant, they have a good argument that it's not enforceable. They never showed me that they bought the restaurant prior to this order that came out and the contract that came out.
But you have that information now, Mr. Hess, correct?
I have it now, and I've already offered to. We can't if they own it. We will not try to enforce it against them and any other Papa Texas's locations. We've asked for all those locations so we don't do this again by accident.
All right, I understand your position. I think, Mr. Robinson, if you feel it's necessary to put on testimony for Mr. Taylor to establish your record, I'll allow you to do that at this time.
Thank you.
All right, Mr. Taylor, if you could raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may proceed, Mr. Robinson.
Please state your name.
Chad Taylor.
Mr. Taylor, are you associated with Papa Texas LLC?
I am.
In what capacity?
I handle their legal administration.
Are you an attorney?
I am an attorney for 28 years.
What is your role in the capacity of handling the legal administration for Papa Texas LLC?
I primarily handle all the litigation matters.
How long have you served in that role?
2 years.
Do you assist Papa Texas LLC in overseeing and managing its franchises in some respect?
I do.
How many franchise locations are you involved in that capacity?
229 Papa John's and about 1,200 total franchises and various brands.
Mr. Taylor, in your experience, is it common in the franchise industry for franchise operators to prominently display on exterior signage who the underlying owner of a franchise location is?
No. For brand identification and continuity, it's pretty much just brand specific type identification. For instance, if you see some golden arches, you recognize what brand that is.
But all those locations are owned by underlying owners, correct?
Correct.
And those may or may not be owned by various business entities, correct?
So within a brand, you could have different ownership structures, yes, as franchisees of the franchisor, which we call corporate, the corporate owner.
In your experience, when a franchise location changes hands, is it common for there to be a noticeable outward change of the franchise look or signage?
No, the outward appearances of those stores stay the same.
In your experience, when a franchise changes hands, is it common for there to be a noticeable change to the menu or ingredients?
No, they do that for continuity purposes.
Can you describe for the court the transition process or procedures that are involved when Papa Texas purchases an existing franchise location from another operator?
Typically, there's a due diligence period that occurs after acquisition. They do things like switch permits, switch vendors. They have to go and switch what they call the POS, purchase operating system. They change merchant IDs. So that's why if somebody comes in and uses their credit card to purchase food, they can go through the purchasing system and they know who to credit that money. We switch utility vendors if we need to for that. So there's a 2 to 4 months of switching operational needs to get that under new ownership.
And you answer my next question, I think, but how long does it generally take for all the operational details of an existing location to be fully transferred to Papa Texas so it can operate smoothly?
Typically about 2 to 4 months.
Were you associated with Papa Texas LLC when it purchased a number of Papa John's locations from PJ Ops Kansas LLC, including one at 7800 East Harry in Wichita, Kansas?
No,
Even though you were not associated with Papa Texas at that time, have you familiarized yourself with that transaction using the company's records and other information?
yes, that is a typical company record that we keep in the ordinary course of business.
Your Honor, I'm going to attempt to do a screen share. These are exhibits that have already been provided. Let's see.
Now things get interesting. Jury trial scheduling hits a wall. Limited court availability, overlapping cases, and even personal commitments are shaping this timeline. The defense seems flexible, but delays can cut both ways. Is this strategy or necessity? And in your opinion, who benefits more from pushing this case further out?
Mr. Taylor, do you see on your screen a document labeled Exhibit 9?
Yes, I do.
Do you recognize it?
Yes, I do.
What is it?
That is an asset purchase agreement for a number of Papa John's franchises.
And this document is 34 pages long. But do you recognize this as being the asset purchase agreement that deals with the property or the location at 7800 East Harry in Wichita?
Yes, I do.
Your Honor, I move to admit Exhibit 9, again, subject to the protective order.
Any objection, Mr. Hess? Exhibit 9 is admitted.
So, Mr. Taylor, do you see here that on page 1 of Exhibit 9 that the location at 7800 East Harry Street is part of this transaction?
That is correct.
And was Papa John's purchasing this location from an entity known as PJ Ops Kansas LLC?
So they were purchasing the franchise, the business operations at that location.
And if we look at pages 2 and 3, Article 1 of the document refers to purchase and sale of assets. Is that right?
Yes,
And if we look at page 3, section 1.3, it has excluded assets, correct?
that's correct.
Was this generally an asset purchase transaction?
Yes, that is correct.
If we look at page 4, there is an Article 1.4. Do you see that?
I do.
Under Article 1.4 of the agreement, was Papa Texas agreeing to assume certain limited liabilities or certain identified liabilities of PJ Ops Kansas?
Yes. Very limited.
And it looks like those assumed liabilities are A and B under Article 1.4. Is that right?
Yes, sir.
So Article A states those contracts relating to each restaurant and to buyer's operation of each restaurant that buyer expressly agrees in writing to accept and assume under Schedule 1.4. Is that right?
Yes, sir.
And B is the leases, and it says collectively the assumed liabilities. Is that correct?
Yes, sir.
In this transaction, was Papa Texas LLC assuming any other liabilities of PJ Ops Kansas LLC?
No, no other liabilities.
If we go to page 33 of Exhibit 9, it has the Schedule 1.4. Is that right?
Yes, sir.
So Schedule 1.4 shows some of the liabilities that Papa Texas was assuming in the transaction. Is that correct?
Yes, sir.
So Papa Texas LLC was agreeing to assume the leases that are detailed on Exhibit A of the agreement, of the asset purchase agreement. Is that right?
Yes, sir.
And then number 2, it was assuming the liabilities under the franchise agreements with the franchisor. Is that right?
Yes, sir.
If we look at page 20 of Exhibit 9, is this the Exhibit A?
Yes.
And if we look at this Exhibit A, does it refer to the lease for the location on Harry Street in Wichita?
Yes. It also has the identical store number for that location.
Mr. Taylor, are you familiar with the standard franchise agreement that Papa John's has with its franchisees?
Yes, sir.
Is there anything in Papa John's standard franchise agreement that requires a purchaser, such as Papa Texas, to assume the liabilities of a seller for garnishments or garnishee judgments?
No, that is not standard or customary in those.
So if the only liabilities that Papa Texas was assuming was the leases and the franchise agreements, is it correct that Papa Texas was expressly not agreeing to assume any garnishee judgment that may exist against PJ Ops Kansas LLC?
That is entirely accurate.
In this asset purchase agreement, again going back up to page 1, did Papa Texas agree to assume any payroll obligations of PJ Ops Kansas LLC?
No, sir.
In this agreement, did Papa Texas agree to assume any withholding obligations of PJ Ops Kansas LLC?
No, sir.
In this agreement, did Papa Texas agree to assume any garnishment obligations of PJ Ops Kansas LLC?
No, sir.
In this agreement, did Papa Texas agree to assume any civil judgments that might exist against PJ Ops Kansas LLC?
No, sir.
In this transaction, did Papa Texas assume or pay any of the utility bills of PJ Ops Kansas LLC?
No, sir.
Through this transaction, did Papa Texas retain the name PJ Ops Kansas LLC?
No, that is an entirely separate, distinct company.
At any time, have any officers or directors of PJ Ops Kansas LLC been officers or directors of Papa Texas?
No,
At any time, have any of the members of PJ Ops Kansas LLC been members of Papa Texas?
no,
Has there ever been any common ownership between PJ Ops Kansas LLC and Papa Texas?
no, sir.
Are you familiar with consolidations and mergers of businesses?
I am.
Was the transaction between PJ Ops Kansas LLC and Papa Texas structured to be a consolidation or merger?
No, this was not a consolidation or merger of two companies. These are separate and distinct companies.
In the transaction between PJ Ops Kansas LLC and Papa Texas, did Papa Texas pay less than adequate consideration for the location at 7800 East Harry?
No, sir.
After this transaction closed, did Papa Texas hold itself out as being a continuation of PJ Ops Kansas LLC in any form?
No, sir.
Mr. Robinson, are you done with the screen share at this point?
I'm going to keep going, Your Honor, with the screen share, if it's okay.
All right, just one thought here. We broadcast these hearings on YouTube. Because of the protective order, are you requesting that that be taken off of YouTube?
I'm not going to refer to Exhibit 9 any further,
Okay.
or I will not display it further, Your Honor.
Okay, go ahead.
Okay.
By the end, the judge locks in multiple dates, balancing uncertainty with structure. This isn't just scheduling, it's positioning for trial under tight constraints. Every delay could shift leverage. The case is set, but far from decided. Like, comment, and subscribe for more gripping courtroom breakdowns and real legal drama.
Mr. Taylor, I have what's on the screen as Exhibit 2. This is a journal entry of judgment that was entered
Your Honor,
my
the
screen.
document speaks for itself. It's a part of the record. It's part of the it's part of the case. It's part of the file. It's part of the court file.
Mr. Hess, I'm sorry.
I object. No, I object. This is all part of the court file, and it's just repetitive and redundant. There's no need to
All right.
continue.
What's the purpose of this line of testimony with this Exhibit 2, Mr. Robinson?
My question for Mr. Taylor is, if Papa Texas agreed to assume this garnishee judgment in the transaction, this garnishee judgment is labeled as Exhibit 2.
Again, Your Honor, the document speaks for itself. There's no need to have
I'll allow it.
the court file.
It's overruled.
Mr. Taylor, in this transaction, did Papa Texas agree to assume the judgment that was entered against PJ Ops Kansas LLC and is labeled as Exhibit 2?
No, sir.
To your knowledge, has Papa Texas ever agreed to assume any judgment against the seller of a franchise location when it purchases that location?
No, sir.
Based on your research, did PJ Ops Kansas LLC disclose this judgment to Papa Texas at any time before the transaction closed?
No, sir.
Had this judgment been disclosed to Papa Texas before it closed on the transaction, would Papa Texas have expressly excluded any assumption of liability under that judgment?
Yes, that's correct.
Had this judgment been disclosed to Papa Texas before it closed on the transaction, would Papa Texas have notified CMK Enterprises, Inc. to prevent future collection efforts at that location?
Yes, that is correct.
Mr. Taylor, Exhibit 3 is an order of garnishment that was entered July 31st, 2018 against the Papa John's at 7800 East Harry in Wichita. In the asset purchase agreement, did Papa Texas agree to assume this garnishment when it purchased the location at 7800 East Harry from PJ Ops Kansas LLC?
No, sir.
To your knowledge, has Papa Texas ever agreed to assume any garnishments against the seller of a franchise location when it purchases that franchise location?
No, because that would not be considered any type of material element of an asset purchase deal. That would be something that would be retained or remain a liability of the seller.
Based on your research, was this garnishment disclosed to Papa Texas before it closed on the transaction?
No, sir.
Had this garnishment been disclosed to Papa Texas before it closed on the transaction, would Papa Texas have expressly excluded any assumption of liability under that garnishment?
Yes, that's correct.
Was Papa Texas originally scheduled to close on the purchase of the location at 7800 East Harry on or about May 15th, 2022?
Yes.
In preparing for this hearing, did you happen to review the closing statement for that transaction?
Yes.
Did Papa Texas actually close this transaction on June 16th, 2022?
Yes.
And Your Honor, since we're being broadcast on YouTube, I'm not going to ask to publish that because it has the financial details of that closing.
Okay, and that's Exhibit 10.
Yes.
Have you offered that? Is that being
No, he
offered?
has not.
I have not, Your Honor. And since we're being broadcast on YouTube, I'm not going to, well, I don't know how to offer that without showing it in a way that's going to make it public.
I can have it taken off of YouTube based on the protective order if that's what you're seeking to do.
If that is acceptable to the court, I would request that.
Your Honor, I object to the admission of this document because he just got it today, number one. And Mr. Robinson said today that the end of presenting evidence was last Monday. So he's in violation of what he's already said. This is a surprise.
Well, Mr. Hess does have a point, Mr. Robinson.
Well, if based on Mr. Hess's statement, the court is not willing to admit the document, then I will just limit it to Mr. Taylor's testimony.
Again, I'll object to that testimony too. They've said today they just found it. This secret document that nobody knows about.
Mr. Taylor, is the truth of, go ahead, Your Honor.
I'm not going to admit Exhibit 10 as it was just produced today. There's been an objection to the court considering testimony regarding the closing. Is that accurate, Mr. Hess?
That's correct, Your Honor. As far as we knew, the property closed in May 15 of 2022. And that's what's been represented to us for quite some time.
And where did the information that the closing occurred on May 15th, 2022 come from?
Came from, previous counsel. It also came from Mr. Robinson. That's what we've been, operating under.
Your Honor, the asset purchase agreement, which the court has a physical copy of, it stated that the parties anticipated a closing on May 15th of 2022. And if you can give me a minute, I can find where that is for you.
Every document that we've seen, the document that was produced is May 15th, 2022.
Is it an Exhibit 9? Is that what?
I believe it is, Your Honor. I'm scrolling through it and trying to find it, and I'm just not seeing it right now. But I can represent to the court that the anticipated closing based on Exhibit 9 was May 15th, 2022. And Mr. Taylor, well, before I start asking questions of Mr. Taylor, as I was preparing Mr. Taylor for his testimony for this hearing, he pointed out that the closing statement actually has a date of June 16th, 2022. And so,
objection, this has not been presented to us. This is facts that are completely different than what's been given to us from the beginning, or from at least for the last 2 weeks.
Right. I'm not going to allow it, Mr. Robinson, as it's just been produced today, when the court had established the previous deadline.
very good. Let's see. Mr. Taylor, let's see if I've got this back correctly. Mr. Taylor, I have on the screen what is Exhibit 6. This is an order for writ of execution in special cases for the Papa John's location at 7800 East Harry that was entered on, looks like May 15th, 2022. Do you see that?
Yes, sir.
Based on your research, was Papa Texas ever provided a copy of this order before any execution efforts occurred under the order?
No, we didn't operate the restaurant at this particular time.
Objection, Your Honor. This is, they said that it's been established that the restaurant was owned by Papa John's, or excuse me, Papa Texas at the time this thing was entered.
Your Honor, well, I'll wait for you to rule.
Well, I'm looking at the document. And Mr. Hess, your objection is what?
Well, he's trying to testify that they didn't own and operate this restaurant on May 18 when this thing was filed, when this Exhibit 6 was filed. It's been established that the contract or the property closed on May 15.
I'm going to overrule the objection.
Do you recall the question, Mr. Taylor?
Yes, we didn't operate this store until after June 16th, 2022. You'll see in the other pleadings, the employees that were named in that were not our employees. The bank account we came from was not our bank account. The initial tilt tap in this was not us. We did not learn about any of this. We didn't get notice of anything until we had sheriffs come into our store last summer and then take $550. And I can tell you how we got here is I immediately determined I was advised what happened because there was a judgment against someone that was not our employee, and they took $550. I immediately called Mr. Hess's office, and I was called and asked for him, and then they said he wasn't there, and they hung up on me. I then called back and asked again, and I was disconnected while I was on hold. I called back a third time, and I was admittedly a little heated at this point because I was trying to explain, and this was the first notice that they had the wrong company. They were executing a judgment against someone who was not associated with us, and I never received a return phone call from Mr. Hess. I understand he says he called me. I never got a call from him. Excuse me, I'm trying to finish my testimony.
Mr. Hess, were you lodging an objection?
I'm objecting to this because this is beyond what the question was too.
Well, I tend to agree with that objection that it's goes beyond what was asked. Yeah, the court understands why we're here. So, Mr. Robinson, if you could ask a different question.
Thank you, Your Honor. Mr. Taylor, had Papa Texas received a copy of this order of writ of execution before any execution efforts occurred, what would it have done?
We would have objected.
Had Papa Texas received a copy of this order before any execution efforts occurred, would it have taken steps to prevent that execution at any future execution?
Objection. This calls for speculation on the part of this witness.
Mr. Taylor is authorized to talk about Papa Texas's business practices.
Overruled.
Yes, that's correct. We would have objected if it's a improper garnishment, execution, anything like that. We take steps to do that. You're correct.
Right from the start, this courtroom heats up as Jason Quinn faces serious felony charges with a massive gap between a 5-year plea and a potential 15-year sentence. One decision could change everything. Will he play it safe or take the risk? Subscribe for more intense courtroom breakdowns like this one.
Looking at Exhibit 7, Mr. Taylor, these are the sheriff's return documents for the order of writ of execution. According to this order, I'm looking at page 5 of Exhibit 7. The Sheriff's Department served the order of writ of execution on June 13th, 2022 at 2:15 p.m. Was Papa Texas operating this location as of that date and time?
No, sir. We did not begin operations until after that date.
It looks like it took $427 from the cash register. Did that $427 belong to Papa Texas as of that date?
No, sir.
According to the notes, the sheriff spoke with a manager named Stephen Carter and spoke by phone with a night manager named Brian Keller. Were those employees of Papa Texas?
No, they could not have been employees of Papa Texas because we hadn't started operating that location, nor had we onboarded any potential employees.
Based on your research, does Papa Texas have any record of being notified by anyone that this till tap had occurred
No,
at
sir.
the time? Had Papa Texas known this till tap occurred, what would it have done?
We would have objected and defended ourselves.
And you've somewhat answered my question, but my next question, but had Papa Texas known this till tap had occurred, would it have ignored it?
No, sir.
Would it have taken steps to stop future till taps from occurring?
Yes, sir. That's what we're doing.
Looking at Exhibit 8, on or about August 19th, 2025, did another till tap occur at the Papa John's at 7800 East Harry in Wichita?
Yes, sir.
And looking at, well, if you recall, did $555 get taken from the cash register?
Yes, sir.
Did you become aware of that till tap shortly after it happened?
Almost immediately.
Who did you get notified by?
The PJ operations team.
When you say PJ operations team, is that part of PJ Ops Kansas, or is that have a different meaning?
That's my abbreviation for short for Papa John's, for the people that do operations, the people that are operating the store. They had notified me that the sheriffs had come in and taken money and provided me with the documentation that was provided to them. And that's when I realized that we had been subject to a improper execution. It wasn't us. It was someone who wasn't our employee, and it involved a different company, the previous owners.
What did you do after learning that this till tap had occurred?
I tried to resolve this with a phone call, and we're here 8 months later or 9 months later. I've had two law firms try to explain to this, and we've had to expend legal fees to get this far, and I'm still trying to get my $550 back. I've had to go the full Monty and incur the cost to get here. I still don't have my $550, and all the briefing so far says that they won't relinquish any type of judgment or garnishment against Papa Texas. I've had to come to court and explain it and get here this far and expend the resources to get here for something like this. I tried to resolve this with a phone call. I tried to resolve this with the Hinkle law firm, and now I'm having to resort to Mr. Robinson and be in court.
Is it sufficient for Papa Texas to have a potential judgment outstanding against it without having it resolved one way or the other?
No, anything that's asserted against us improperly, we're going to try to resolve.
Has CME Enterprises or its counsel ever stated to Papa Texas that it agrees the garnishee judgment is not enforceable against Papa Texas?
No, this is the first time that I'm hearing that today in court. And there was also a previous letter that was written by Mr. Hess that asserted that we were wrong and that my facts were wrong.
Does Papa Texas seek an order from this court stating that the garnishee judgment by CMK Enterprises against PJ Ops Kansas LLC is not enforceable against Papa Texas?
Yes, and I've tried to resolve this before coming here today, but if this is what it takes to get an order to make it to get finality and resolution, yes, that's exactly why we're here today.
Does Papa Texas seek an order from this court preventing CMK Enterprises from continuing to collect its garnishee judgment from PJ Ops Kansas LLC?
Correct. We are the improper party.
But is Papa Texas trying to prevent CMK Enterprises from going forward against PJ Ops Kansas LLC and trying to collect the judgment from them?
No, if he wants to go try to enforce the judgment against PJ Ops, the previous owner, he's free to do so.
Thank you, sir. That's all the questions I have.
All right, thank you, Mr. Robinson. Cross-examination, Mr. Hess.
Isn't it true that you did call me in August of 2025?
Yes, sir.
And my receptionist accidentally cut you off from the phone call twice. Is that correct?
I can't understand what you're saying.
My receptionist cut you off accidentally in August of 2025.
Yes.
And isn't it also true that I called you back and left a message on your recorder?
No, I have no record of that. We also have a digital system that records calls, and I have no record that you called me ever.
I called you on that afternoon before 4 o'clock after you demanded that I call you back.
Your Honor, I'm going to object and move to strike. The statement of Mr. Hess there is his testimony. It's not a question.
Sustained.
Now, Mr. Taylor, the whole idea of changing ownership of 7800 East Harry is so that no one knows that there's been a change of ownership. Is that right?
I'm sorry. Due to the audio, I can hear about a third of what you're saying, and it's not coherent.
Isn't it true the whole idea of the sale, changing ownership of 7800 East Harry in Wichita was so that no one would know that there had been a change in ownership?
Again, I can't understand what he's saying. Can someone else with somebody translate for me? What's the aim of the question?
I'm having a hard time hearing it as well.
I apologize, Your Honor. I don't know what the problem is with the connection. Yeah, isn't it true, Mr. Taylor, that the whole idea of changing ownership at 7800 East Harry in Wichita was so that the public would not know that there was any difference in the Papa John's?
I think I heard the question as, did we identify the location as a Papa John's in Wichita?
Well, that's in part true, but yes. Was that true or not?
Okay, yes, the store is identified as a Papa John's in Wichita. However, the ownership is usually not displayed on the outside of the restaurant.
So the ownership at 7800 East Harry, the change ownership is a secret, basically.
No idea what he said.
He asked if the change of ownership was a secret. Is that correct, Mr. Hess?
Yes, that's correct.
No, I don't believe the change of ownership was a secret, but the terms of it are not disclosed publicly, just like every other private business transaction.
So the contract for the sale of 7800 East Harry is a secret and is protected.
I don't know what he said.
He asked if the contract for the sale of that location in Wichita was a secret, that it was protected.
No, the fact that the location that the business changed hands is not a secret. I'm sure he could have called Papa John's corporate and asked before he did his execution to identify who the correct operator of that restaurant was. Additionally, within the restaurant, there are posted other notices like permits, health department permits, stuff for the fire marshal that identifies who the current operator of the restaurant is. It may not be on the front door, but it's posted as a matter of law in every restaurant.
The Papa John's purchased the business operation at 7800 East Harry in Wichita, and they continued the business operation as a pizza parlor, did it not?
I don't know what he said.
Could you repeat the question, Mr. Hess?
Yeah, Papa Texas continued the operation of 7800 East Harry as a pizza parlor after May 15th, 2022.
Yes, that particular location continued as a Papa John's restaurant.
And Papa John's held itself out. Excuse me. Let me rephrase that. I got to get my Papa John's correct. I apologize. Papa John's Texas held itself out as being a continuation of the pizza parlor that was there prior to May 15th, 2022.
No, it continued as a location for pizza. It is not a continuation of the same previous ownership company. Franchisee stores change almost frequently.
Papa's Texas sold pizzas at 7800 East Harry in the same manner as the previous Papa John's sold pizza at 7800 East Harry.
That location remained a Papa John's store.
And it sold Papa John's pizza.
It is still Papa John's today.
And it's held out to and the public did not know any difference between the sale of the operation of 7800 East Harry before or after May 15th, 2022.
I'm going to object as misstating the previous testimony of Mr. Taylor about the public notices and signage.
I'm not asking about public notices. I'm asking about the public, the general public, people who go into the store.
I'll overrule the objection.
Yes, so anyone who wants to learn who the current operator of that store is could walk into the store and ask to see the permits. And they're typically posted. That's how city officials and other health inspectors come in and have all that information readily available right to them. And it's up to date. It has to be up to date.
Well, isn't it true that there was a till tap of the 7800 East Harry, which began on May 16th, 2022?
I'm sorry, I didn't understand the question. I can't hear.
He asked if there was a till tap at the Harry location that began on May 16th, 2022. Was that the question, Mr. Head?
That's correct.
I do not have firsthand knowledge of that. We did not operate this particular store on May 22nd of 2022. We did not begin operations or take over operations as the new franchisee until June of 2022.
I believe you previously testified that if you would have known of the till tap that occurred on during the time after May 16, 2022, you would have objected and protected itself as of 6/13/2022. Is that right?
Yes, had that particular tilt tap been against us and say Papa Texas, we would have defended and objected that. That's what we're doing today is, again, this judgment is not against us. It's not against one of our employees, and we're objecting.
But you did not object or protect yourself from the 6/13/2022 till tap.
Again, we did not operate this store or control it on that date.
Your Honor, no further questions.
All right, thank you, Mr. Hess. Redirect, Mr. Robinson.
No, Your Honor, thank you.
All right. I'm going to go off record real quick. Kim, are you on here?
Yes.
Do you have the ability to communicate by email with Attorney Jim Hargrove or Joy Williams regarding my 3 o'clock?
Yes, I can certainly get a hold of them.
If you would be able to communicate with one of them that we're running late, and we'll get started as soon as we can, please.
I will certainly do that.
Okay. All right, we'll go back on the record. Mr. Robinson, do you have additional evidence to present?
No, Your Honor, thank you.
All right, Mr. Hess, do you have evidence to present?
Yeah, I want to have my receptionist and my office manager come in so they can testify that I did call Mr. Taylor back.
Okay.
Hold on just a minute. I'll go fetch it.
This is the turning point. Quinn officially rejects the plea deal after confirming multiple times it's his voluntary decision. Legally, that locks him into facing full charges at trial. The safety net is gone. Do you think he truly believes he can win? Or is this a gamble that could seriously backfire?
Daniel, Gary, get in here. I want you. It's that pizza thing. I did call him back, didn't I? Sit in the chair, please.
Okay. Hi, I'm Carrie Nelson.
Better speak into the.
Can you hear me? Hi, I'm Carrie Nelson. An assistant to Scott.
Okay, the audio coming from that computer is, it's hard to hear.
Okay, I'll talk louder if that will
Okay.
help. Okay.
All right. What is your name, ma'am?
My name is Carrie Nelson.
Could you spell that, please?
Yes, Carrie. Last name is Nelson. Nelson.
All right, ma'am, if you could raise your right hand, I'll administer an oath. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Hess, you may proceed.
Ms. Nelson, would you please state your name again?
Carrie Nelson.
Ms. Nelson, what are your duties at the office of Newman Hess and Associates?
I'm office manager.
As the office manager of Newman Hess and Associates, were you on duty on, I believe it was August 19th, 2025?
Yes.
And on August 19th, 2025, did Mr. Chad Taylor call the office?
He did.
And how many times did Mr. Taylor call?
2.
Did our receptionist cut Mr. Taylor off accidentally?
He did. It was an accident.
And did Mr. Taylor call back?
He did.
And did Mr. Taylor leave a message for me to call?
He did.
And what did Mr. Taylor's message say?
That he wanted you to call before, I think it was 3:00. Was it 3? And I told him I would text also, which I did. But Scott was in court, so he couldn't receive any phone calls at the time.
Ms. Nelson, did I call Mr. Taylor back before the time that he asked for me to call him back?
You did. You came in beforehand and called immediately.
Your Honor, I'm going to object and move to strike. It's not relevant to the purposes of this hearing.
Well, there's been testimony regarding this exchange from Mr. Taylor, so I'm going to allow it.
Thank you.
Did I call Mr. Taylor back?
You did call him back before the time he asked.
Did Mr. Taylor take the call?
He did not.
Did I leave a message for Mr. Taylor?
You did.
Did Mr. Taylor ever call me back?
He did not.
Have I tried to resolve this matter with Papa's Texas?
Yes.
Did Mr. Taylor identify himself as working for Papa Texas?
It was like Sun Corporation. He didn't mention the Papa John's restaurant.
But he didn't identify himself as representing Papa's Texas?
No.
No further questions.
All right, Mr. Robinson, cross-examination.
I have no questions for this witness, Your Honor. Thank you.
All right. Thank you for your testimony, Ms. Nelson. You're free to go.
Thank you.
All right, Mr. Hess.
Any other evidence would just be redundant, Your Honor. I'll leave it at that.
All right, so no further evidence, Mr. Hess?
No, unless I could, accept the recorded phone messages that I could proffer. And I'd need to mail them down to you on a flash drive, and I'll send one to Mr. Robinson also.
Your Honor, I'm going to object to those recordings. If Mr. Hess is not willing to agree to our Exhibit 10, which we did provide in advance of the hearing, I'm not willing to agree to have the court consider evidence or exhibits presented after the hearing.
I'm not going to allow the recordings of the phone calls.
Very good.
All right. Mr. Robinson, do you wish to make closing argument?
Yes, Your Honor. Thank you. The general rule in Kansas, which is stated in in Wells Fargo Vendor Financial Services LLC versus Nationwide Learning LLC, 56 Canap 2nd 259, 2018, is that when one corporation sells or transfers all of its assets to another corporation, the purchasing corporation is not liable for the debts of the selling corporation. That is the general rule. Again, there are 4 recognized exceptions. In order for any of those exceptions to override the rule, CME Enterprises LLC has to come forward with evidence showing that one of those exceptions should apply. Papa Texas has come forward with evidence showing that this was an asset purchase in all forms. This was an asset purchase agreement. There was no consolidation or merger. And I think the only argument that CMK Enterprises has to this being a continuation of the selling corporation is that it was a Papa John's when PJ Ops Kansas LLC owned it, and it was a Papa John's when Papa Texas owned it. And therefore, as a matter of law, the general rule that asset purchases don't apply shouldn't apply to any sale of a franchise. That is a nonsensical argument, Your Honor. As Mr. Taylor testified, these franchises change hands from time to time. Indeed, CMK Enterprises, it was, perhaps still is, an operator of a Pizza Hut franchise. So it with, above probably any other party, understands that the franchise that you operate, the franchise brand that you operate, is not necessarily the same company. If this were the case, then in Kansas, there could not be asset purchases and sales of franchises, because as a matter of law, whoever purchases that franchise is a continuation of the selling corporation, and it is accepting all the liabilities of that selling corporation, because it was a Papa John's before and it's a Papa John's now. Well, that really overrides all the concepts of freedom of contract and the intent of the parties in these commercial transactions.
Now things shift. Another defendant admits to missing court, resulting in a contempt finding. That's huge because it shows how seriously judges treat compliance. Even with explanations, accountability comes first. It raises the question, are these defendants underestimating how strictly courts enforce rules, or just struggling to keep up?
CMK Enterprises has the burden of showing that that any of these 4 recognized exceptions applies. It hasn't come forward with any evidence. The only evidence that it came forward with was the testimony of Mr. Hess's office assistant, that a phone call was made, or phone calls were made back and forth. That does not establish that any of these exceptions should override the rule in Kansas. As Mr. Taylor stated, when the till tap occurred in 2022, Papa Texas was not operating this location. The sheriff did not communicate with employees of Papa Texas. The sheriff did not take money of Papa Texas. Papa Texas was not notified of this till tap. Had it done that, had it been notified, it would have acted. And the reason we know that to be the case is because when the 2025 till tap occurred, Mr. Taylor was on the phone very quickly and trying to deal with this matter. So none of these exceptions apply. The court should apply the general rule in Kansas. Papa Texas is not trying to prevent CMK Enterprises from continuing to pursue PJ Ops Kansas LLC to collect this judgment. It should still be free to do that. All we're asking is that this judgment be declared unenforceable against Papa Texas LLC. Thank you.
Thank you, Mr. Robinson. Mr. Hess?
Your Honor, Mr. Robinson refers to the Wells Fargo company. There's 7 elements. 3 of them would apply to this particular instance. The purchasing company continued, which is purchasing company being Papa Texas, continued the business operation of the selling company. They were selling pizzas. They continued to sell pizzas. Nobody knew that there was a change in ownership of this company. The purchasing company held itself out to others as a continuation of the selling company. It held itself out to be a Papa John's, and it was selling pizzas. Nobody could have known the difference about that. The purchasing company assumed the paid liabilities ordinarily necessary for the uninterrupted continuation of the selling company's business. In May of 2022, there was a till tap of the Papa's at 7800 East Harry in Wichita. We were led to believe, because there was no objection made, and Mr. Taylor did say that he would have objected and protected on the 6/13/2022, but chose not to do that. So 3 of the elements of the Wells Fargo case are present, and 3 of the 7 elements are present. And quote, no one element is necessarily decisive, nor must all elements necessarily exist together. So arguably, if one of them is present, the Wells Fargo elements are met. Further, we've argued that latches does apply because these folks did not object to the till tap that occurred on May 6th. It started on May 16th, and the payout was made on July 7th, 2022. Doctrine of latches is equitable, and we have clean hands in this matter because we've offered to give the money back to these folks, and they decided that they didn't want it, and they wanted to fight over it. Equitable estoppel would be applicable in this case too. We've had consistency of conduct. We've continued to try to collect this judgment against the business that was at 7800 East Harry. We thought legitimately that it was the same business that we got a judgment against in 2018, 2022, when we got a till tap there. In 2018, we got a till tap in 2025. There was no reason for us to believe otherwise. We've attempted to get this thing resolved, and we've run up against a stone wall the entire time. Your Honor, we asked for the contract. We didn't get it until about 2 weeks ago. I just don't know what to say. We've been trying to take care of this for quite some time to no avail, and we will not. Now that we know that the restaurant at 7800 East Harry is not owned by the entity that we have a judgment against, we will stop. And we also have asked for all restaurants that Texas operates, so that we don't do this again. We want to know who owns what, so that we can execute on our judgment. Nothing further.
All right, thank you, Mr. Hess. Mr. Robinson, I'll give you a chance for brief rebuttal if you wish.
Thank you. To say that nobody knew that the company had changed hands in 2022 is inaccurate. Mr. Taylor testified that if you want to know who owns a particular franchise, all you have to go do is walk inside and look at the permits on the walls. It will tell you who is operating it. Mr. Hess said that Mr. Taylor chose not to object in 2022, but Mr. Taylor testified that he didn't know that this had happened back in 2022, and if he had known, he would have objected. Mr. Hess mentioned the concept of latches, but as noted in the reply, and Ford versus Willits, this is on page 5 of the reply, and Ford versus Willits, 237 Can 13, the Supreme Court held that latches cannot be asserted to bar an action to set aside a void judgment. This is a request to set aside a void judgment. laches cannot be asserted as a defense to that. In terms of equitable estoppel, the Kansas Court of Appeals has stated that in order for equitable estoppel to apply, the party trying to invoke it must show prejudice. There is no prejudice to CMK Enterprises because it still has a valid enforceable judgment against PJ Ops Kansas LLC. And the statement that CMK Enterprises and Mr. Hess will voluntarily stop trying to collect against Papa Texas really is beside the point. The bottom line is that CMK Enterprises claims that it has a valid judgment against my client. My client has a legal right to have a declaration from this court saying that this judgment is not enforceable against Papa Texas. It doesn't matter as a matter of law that Mr. Hess and CMK Enterprises says, well, we will voluntarily cease. That's not good enough. Papa Texas has a legal right to have a court say that this judgment is not enforceable as a matter of law against it. That's what it's trying to do here today. That's why we ask that the motion be granted. Thank you.
All right. Thank you, Mr. Robinson. All right. I had an opportunity prior to the hearing today to read through all of the briefing. And I've now listened to the testimony and arguments and statements of counsel. The evidence in this case is the judgment was against PJ Ops, who is operating the Papa John's, or the owner of the Papa John's facility at this Harry location in Wichita. The Papa Texas purchased that location from PJ Ops in, well, there's testimony originally that a closing was to occur May 15th. Testimony was that it actually occurred later in the summer. The general rule in Texas, as outlined in the briefing, or the general rule in Kansas, is the Wells Fargo versus Nationwide learning case. That in these types of purchases, unless the purchaser was expressly agreeing to the debts, that those debts don't follow the purchaser. In this case, the exception that's being raised is that the purchasing corporation is merely a continuation of the selling corporation. Well, in this case, there are no common officers.
Here, Aubrey takes a very different path, accepting a plea deal to a lesser charge, avoiding harsher penalties, and habitual enhancements. The judge carefully confirms every right waived, locking the plea in. This decision trades uncertainty for control, but consequences remain, including possible restitution and license suspension tied to the offense.